Gentlemen, please be seated. All right, we're here on Defendant Flagstone and City of Miami's motion to dismiss a plaintiff's verified complaint, as well as a request for postponement by the plaintiff. Parties, please state your appearances for the record.
Your Honor, I'm Sam Duggan on behalf of the plaintiffs.
Welcome.
Good afternoon, Your Honor. Forrest Andrews on behalf of the City of Miami, and also present are the City Attorney for the City of Miami, Victoria Mendez, and Assistant City Attorney Stephanie Panoff, and Robin Jones-Jackson.
Good afternoon.
Good afternoon, Your Honor. I'm Alan Diamond, and with me is Tim Kalaya with the Greenberg Short Firm, together with our co-counsel Jeffrey Bass from Shubin Bass, General Counsel for Flagship Natalie Guillaume.
All right, good afternoon. Again, I want to welcome everybody. I know plaintiffs late yesterday filed a motion for postponement. I thought we would reserve about 5 minutes to address that first.
Thank you, Your Honor. May I quote?
You may.
This is an additional document that I supplied the other side with before the hearing. This is the deposition of the city's representative, Aldo Bustamante, who was required by Judge Trawick in the other case to talk about the city's compliance with Mr. Herbert's public records requests. And as I indicated in the letter yesterday, what the city produced was a permit that was ostensibly issued by the Public Works Department on August 15, 2014 for the Mega Yacht Marina portion of this development. Now, one of the central questions in this complaint, count 5, is whether the defendants should be allowed to proceed with this entire project because the developer failed to meet the June 2nd deadline. That was a very hot topic at the City Commission meeting on May 8th, whether or not the city would even allow them to go forward. But one voted no. Two commissioners said, well, the legal department told us we have to let them get to June 2nd, so we'll let them get to June 2nd. Now, and then on August 15th, Mr. Herberts had to sue the city to get records they were withholding for 3.5 months. That's not disputed. And Judge Trawick ordered them to produce them on a rolling basis and to allow plaintiffs to take the depositions of the witnesses to ensure that all of the documents had been produced. So we took Mr. Bustamante's deposition in November 2014. He testified that every single document that was responsive to Mr. Herbert's request under Judge Trawick's order had been produced. Now, this supposed permit dated August 15, 2004 was never previously produced. Now, this is what's called a smoking gun in litigation parlance, because this is something the city hid from Mr. Herberts, hid from the order to produce, and hid from the public because it demonstrates that they went out after the June 2nd deadline to get this permit. And it's consistent with the pattern of illegalities ranging from the violations of the public records law, forcing Herberts to go to court 3 separate times to get those records, and the suppression of information that would show that they're violating the charter by allowing this project to continue to have life after 10 years of failure. The appraisals that you read about, the traffic studies, and all of this information about the commencement of construction. Because this document should have been produced in their electronic search, because the search terms include Flagstone, which is in the emails that I produced yesterday, somebody didn't produce that permit. Somebody didn't produce those emails showing that they were scrambling to get that permit in the middle of August of 2014. That not only calls into question the validity and the integrity of the city's process dealing with that issue, but everything, because the appraisals, the traffic studies, these are all part and parcel of the suppression of information about the impact of this project on my clients and the violation of the charter that the city manipulated on behalf of this private developer. That's what this case is all about, that the charter was violated and that the impact on my clients and their neighbors was suppressed by the city in the process of trying to breathe oxygen into this project, which had gone nowhere for 10 years. So this discovery calls into question everything. We request that we get to go back to now Judge Rabul, who's the new judge on the case, and make sure that the city has produced everything so that the Third Amendment complaint can be current, up to date, with every possible shenanigan that the city has undertaken in the process of violating its charter, putting my clients in harm's way with all of all of the, special injuries that we've alleged in the Third Amendment complaint.